Okay, it looks as though the numbers are slowing down a little bit, so possibly not. I'll start with the introductions anyway, and those who come in will get the drift of where we're heading, and hopefully be able to join us before we start with the main proceedings. So thanks very much to everybody for coming this afternoon to Doughty Street Housing Team's Possession Update, July 2022. I'm very pleased to be introducing two fantastic speakers today. David Carter, who I'm sure will need no introduction for most, if not all of you. I think it's fair to say, certainly it's my approach to problems in my own practice that if David doesn't know the answer, then there probably isn't one to keep on looking for, and leave it there. He brings a wealth of possession and other housing experience, and is going to talk to you today about some of the case law that's been going on over the last 12 months or so. He's joined by Marie Paris, who joined Chambers much more recently in 2021. Coming from a background working in law centres, it's fair to say that she's made a stratospheric start to her career in Chambers and is a finalist in the Young Legal Aid Lawyer of the Year Awards housing category for this year, and she'll be dealing with some of the policy and context developments that have been going on, particularly with the end of the COVID arrangements. I'll hand over to Marie and David in a moment, just to deal with some of how this afternoon is going to work. First of all, questions. If anybody has any burning questions, feel free to direct them to us as we go along. But I think for the majority of the questions we'll come to those at the end of both presentations. You'll all get a copy of the slides. That's often the first and possibly only question I get in the questions at the end. So yeah, copies of the slides will be sent out to everybody who's attended following this. There are two other things that will be going on at the end. The first is that there's a new feedback poll being used today, which you might not have seen before, which will be posted to you, I think, through the chat, or it will pop up for you at the end. And if you can take a couple of moments to complete that, that would be very much appreciated. And the final point to mention just at the outset, in case I forget later, is upcoming webinars. We've got a busy programme over the next few months in the housing team. So on the 13th of July, we've got a seminar on adaptations. And on the 12th of September, we've got a further seminar about challenges to allocations policies. But again, a link will be posted to our events page in the chat during the question and answer session at the end, so that you've got all of those details available. So with that, I'll pass over to Marie, who's going to present first. So Marie, over to you.
Thanks, Dan. I'm going to be covering the sort of return to normality, to life back before COVID, and see if anything from the arrangements that happened during the pandemic are left over, and then briefly looking at the Renters Reform Bill and how it impacts on possession proceedings and the new grounds of possession. So if we could have the first slide, there we are. So on the 1st of November 2021, I think it will probably be news to nobody that the overall arrangements for possession proceedings have come to an end. So that's the sort of informal guidance that was given out to courts that was published as well, which was regarding listing for review dates. So that's probably the most substantial change. So no longer will there be mandatory review dates before substantive hearings, though some courts can choose to do so on their own discretion. And the courts no longer need to prioritise certain possession claims, though more on that a bit later, because it might feature in the Renters Reform Bills, those new priorities. But for now, there's no strict prioritisation. On the 30th of November 2021, the interim period under Practice Direction 55C, so the temporary practice direction for possession claims during COVID, technically came to an end, but Practice Direction 55C will continue to apply to any possession claim issued before the 1st December 2021. The most substantial way that works is that on the stayed claims issued after the 1st of December 2021 still need to be I think I should say before the 1st of December 2021 still need to be reactivated unless they were issued on or after the 3rd of August 2020 or a possession order has already been made. The other sort of remaining change from these this alteration to possession proceedings during COVID is that until the 30th of June 2022, for all claims issued on or after the 3rd of August, the claimant has to demonstrate compliance with the relevant PAP. So really that's only going to be the pre-action protocol for social landlords and the mortgage repossession pre-action protocol, and provide information about the effect of the pandemic on the defendant or defendants. So that's the usual notice talking about the knowledge you have of how the pandemic has affected the defendants. So that's still in place until the 30th of June. Next slide, please, Ray. Whilst those notice periods that we saw before, the modified notice periods during COVID, have returned basically to what they were before the pandemic, do continue to pay attention to the relevant notice period for older claims. So I've done a very basic table here with just I think the sort of headline notice periods that you have to be aware of. If you want more detailed information about each different ground and what notice period was in place when the notice was served or said to have been served, there's still technical guidance online. It says withdrawn in big capital letters on it, but if you type in technical guidance for eviction proceedings, it will still show you what the notice periods were for different types of possession claim. So section 21, if it was between the 29th of August and the 31st of May 2021, they needed to have 6 months notice. That reduced to 4 months until the 30th of September 2021. And now we're back to normal on 2 months. Rent arrears, I think everybody knows, but it's 4 weeks where you are more than 6 months in rent arrears between August and May 2021, 6 months otherwise. And then from that point to the 30th of September 2021, it was 4 weeks where there were, again, 6 months or more in arrears, and then that reduced to 4 months otherwise, until the 1st of August, where it became 2 months. So it's a bit finicky, needless to say. So I think it's a very good idea if you see any notices that are served in these periods. I didn't include the earlier periods because those notices will be out of time. But in these periods, it's good to look back at that technical guidance just to make sure that the notice periods complied, because it was quite difficult. Ray, next slide, please. Lovely. So this is just a little bit about breathing spaces, which are quite useful. Though I've not come across many cases where breathing spaces are raised. It may be because they don't need to come to me, which is good news. But this is one sort of lasting difference that's come to us post-pandemic. So the regulations come from the Debt Respite Scheme, brackets, Breathing Space Moratorium, Mental Health Crisis Moratorium, and obviously England and Wales regulations in 2020. So the main headlines for the debt moratorium are that any rent or mortgage arrears can be included. The tenant or the mortgager remain liable for the debt throughout the period, but the regulations limit what the landlord or the lender can do to enforce the debt for a period of 60 days. So one of the limitations is that they cannot demand payment of the debt included in the moratorium, and they cannot charge interest during the breathing space. Landlord can't serve notice on rent arrears grounds during the breathing space. Of course, they can continue to serve notice on other grounds, including section 21, which they may well have served because of the rent arrears, but technically they can do that. They can't issue claims on arrears grounds during the breathing space, though the time limit for issuing a claim will be extended for 8 weeks if it falls during the breathing space. So if they needed to have issued, say, within a year, they'll have a year and 8 weeks if that year falls within the breathing space, which I think is only fair. And they cannot enforce possession orders. Landlords have to notify the court of any breathing spaces in place if there are ongoing proceedings. So that's very important. They have to let the court know. And the court, upon knowing, has to adjourn any ongoing proceedings to the first available date after the breathing space ends. Next slide, please, Ray. There we are. The other type of breathing space provided for is the mental health breathing space. And this is for anybody who's receiving treatment from a specialist mental health service, if they are receiving that treatment for a serious mental disorder. So it would apply to people, say, who are being treated under section. I've had clients who've been served notices whilst in hospital receiving treatment under section. So whilst it may feel like we don't need this, it actually is quite necessary. It lasts for the length of the treatment plus 30 days on the end, which is nice. You can enter into as many as needed. So that's in contrast to the debt breathing space, where I think you can only enter one a year effectively. It can be on application for the person who owes the money themselves or from a third party, such as a social worker or a mental health professional. And here, if there are ongoing possession proceedings, whilst there's a breathing space in place, the court has to adjourn generally and then list a review date for 6 months for directions. So that's 6 months after the start of the breathing space is the time that they should list for review. So that's different to the debt breathing space, where it's just the first available date. So any steps that are taken contrary to the regs will be void. So that's very significant. Though it is possible for the court to give permission where it considers it's reasonable and not detrimental to the tenant, but it's hard to see when it would be not detrimental to the tenant. Debtors can't be evicted during a breathing space of any kind. And importantly, if they are evicted in error, they can apply for their restitution, and I believe they can claim in damages. And I've given a case there called Lees and Kay, which Daniel did, and he'll be talking to you a bit about it in the end. But there we are. The point is that you can't enforce an order. You can't enforce a possession order, and if you do, there may be consequences for you. Looking now to the future, now we've gone past the past. This is just a brief summary of the Renters Reform White Paper and what I find interesting in that paper. I'm sure everybody's heard of it. It's been whispered about for a long time. So in April 2019, the Housing Department consulted on proposals to end the no-fault evictions and extend the ground under Section 8 and restrict the landlord's ability to grant assured short-hold tenancies, so usually those 6 months or 1 year tenancies. Though not much happened on there, and I think it's fair to say there's a fair bit of cynicism as to whether anything would happen in the future. In November, it was included in the Conservative Party manifesto that they would be abolishing Section 21. And then, somewhat out of nowhere, I don't know if that's fair to say, but I was surprised to see on the 16th of June this year, the ministry released a white paper called A Fairer Private Rented Sector. And in that white paper, it describes reforms that are going to be called a New Deal for renters, capital letters, centered on quality, affordability, and fairness, which all sounds very good. And in fairness, if you dig into it, even with the most cynical eyes, I have to say, on a personal level, I couldn't fault it very much, but let's go into more detail. So the next slide, please, Ray. The headline reforms in regard to possession proceedings anyway are listed there. So it does look like we are finally seeing the end of Section 21 no-fault evictions, though there are still going to be no-fault evictions, but slightly modified. What's interesting is that they are abolishing, is the language used, I think, assured short-hold tenancies. And I'll explain a bit more on that later, but I think that's very significant. They are going to introduce a sort of private rented sector ombudsman, and that's going to be for everybody in the private rented sector, unless you're in student accommodation. It's altering, or they say strengthening, the grounds under Section 8. So a balancing act, really. They're getting rid of no-fault evictions, but they should be making it more streamlined and efficient to achieve possession through other means. And then they are hoping to apply the decent home standards and enforce them in the private rental sector. So at the moment, they only apply in social housing. Next slide, Ray. Thank you. So here's the end of Section 21. So all assured or short-hold or periodic tenants, which is the language used, which is a bit strange, will be moved onto a single system of periodic tenancies. So the good news is it's much more flexible for tenants if this all happens, but the proposals are it will be much more flexible for tenants. So tenants will only need to give 2 months notice, and there's no suggestion that they have to give any good reason for giving that notice or anything like that. Whereas landlords will only be able to evict tenants in reasonable circumstances, which will be defined in law. More on that later, but the idea is it's effectively sort of lopsided. So tenants can give 2 months notice from the look of the paper at any point from the commencement of the tenancy, and landlords will only be able to evict you with reasonable grounds. That's not to say they're discretionary grounds, but in reasonable circumstances. Unfortunately, the only people that won't be included, there's a specific exemption for purpose-built student accommodation. So sort of licensed accommodation, your nights, that won't be included. But if you're a student, obviously living in a normal assured short-hold property, that will be included. So here's a bit about the new grounds. So these are the sort of supposedly strengthened grounds for possession. The first ground is the same as the old grounds, really. So what they are making clear is that it will still be possible for landlords who are wishing to sell their property, or this is a bit novel, let family members move into the rented property to get eviction without having to prove that the tenant had done anything wrong. But they won't be able to do so in the first 6 months of the tenancy, and that's explicitly to mimic Section 21. But it will only be if they wish to sell the property or let their family members move into the property. So that's something that will presumably have to be proven as it is now. There is a new or sort of modified ground for what they call repeated serious arrears. So the idea here, which we're told that the landlord association, is it the Residential Landlord Association, was upset about, that apparently frequently happens, is that tenants will show up to a Ground 8 hearing and very sneaky tenant lawyers will say to them, look, just pay £2 to get you below the level needed for Ground 8. I have in my few years never seen that work very effectively because it's difficult to get people to pay below Ground 8 if they're already in that position. But apparently it's something that happens very frequently. So to deal with that, they've introduced, or they're going to introduce, this new ground that says eviction will be mandatory where a tenant has been in at least 2 months rent arrears 3 times within the previous 3 years. So the idea is that they're persistently in serious rent arrears. So regardless of whether you clear that down to potentially to 0 at the date of a hearing, that will still be a mandatory ground. So that's something to look out for, but I'm sure we can find ways to argue around that. There's going to be an increased notice period for rent arrears grounds. So it's going from 2 weeks to 4 weeks. So again, that's beneficial for tenants. There is, again, another sort of more benevolent approach to tenants is that there's recognition in the white paper that people who fall into Ground 8 territory oftentimes do so because of the timing of their universal credit or their housing benefit. And it provides here that they'll prevent tenants in this scenario from being evicted, provided it is the reason they exceeded the mandatory rent arrears threshold. So I imagine lots of people are going to have fun trying to work out what on earth that means in practice and trying to unpick that. But we'll see. And what it doesn't say, which I think is a significant omission, is it doesn't say just sort of general benefit problems. It says timing of their benefit payment. So I think we're still going to struggle if we go in on a Ground 8 case and say, look, they're going to get a benefit payment tomorrow because they've been denied benefit for unlawful reasons. That's still going to be a Ground 8 claim. They're also going to reduce the notice period for mandatory ASB grounds, but it doesn't say from what to what. And they're going to introduce a new specialist ground, which is very vague, the way that it's written, a specialist ground to assist people who provide temporary and supported accommodation to continue to provide the service, I think is the words used. I'm not quite sure what that's going to be or what that's going to look like. It might be, it looks like something that could be quite draconian, but hopefully not. And the notice period where a ground is something beyond the tenant's control, generally speaking, will be at least 2 months. Next slide, please. So there's quite a lot of time spent in the white paper talking about reforms to dispute resolution generally. So how landlords and tenants can resolve the disputes that arise, because there seems to be some consensus between the tenants consulted and certainly the landlords that at the moment, possession proceedings are taking too much time and too costly. And they're not fit for purpose. They're not serving tenants either. So one change that they're making is that they're going to increase the notice period for rental increases to 2 months. And they're going to end the use of rent review clauses and automatic rent increases. So that just means that when there's a clause in the tenancy, very often nowadays in AST, that says at the end of this tenancy, when you renew the tenancy, if you renew the tenancy, the rent will increase by whatever percentage. That's apparently going to be prohibited. And the first tier tribunal is no longer going to be able to increase the rent beyond a landlord's initial demand and the increased notice. So that's to prevent tenants from being frightened from challenging a rent increase because at the moment, if you challenge a rent increase, there's a chance that the first tier tribunal will actually raise it to a higher level than your landlord had initially asked for. That can no longer happen, apparently. There's expanding rent repayment orders to include sanctions for non-decent homes. So it's this idea that the decent home standards is going to be extended to private rented sector, and there appears to be some sanctions with a bit of teeth, or that's at least the intention. And interestingly, there's this introduction of the ombudsman for the entirety of the private rented sector. So everybody has to be a member, even if you're a landlord. It says so explicitly, even if you're a landlord who largely or exclusively uses agents, you'll still need to be a member of the ombudsman. Councils can enforce if the landlords fail to join. So that's the idea. There's a suggestion that councils will be able to give some sort of sanction, maybe criminal, if a landlord fails to join. And the landlords will have powers to put things right for tenants. The ombudsman, sorry, will have powers to put things right for tenants, including compelling landlords to issue an apology. I'm sure that's what we're all after, really. Provide information, take remedial action, and or pay compensation of up to £25,000. So that is significant. And I think I've certainly, in my own experience, had good experience with other ombudsmen, and that you can get a faster resolution than you may otherwise do having to go through court. And for things that may not necessarily be unlawful but are unpleasant. So that I think I'm quite hopeful about this ombudsman if it does come to pass. And what is mentioned very briefly, but I think is quite significant for practitioners, is it seems to me that the idea of the specialised housing court that's sort of been hovering around in the ether for a long time now has finally been put to bed. So what it says is, whilst they are still not pleased with the way possession proceedings are dealt with, they said that the costs of a housing court outweigh the benefits. So they're not going to be proceeding with that. But what they will be proceeding with, they say, and I quote, they will introduce a package of wide-ranging court reforms that will target the areas that particularly frustrate and hold up possession proceedings. And they've identified those areas as county court bailiff capacity, oh dear, paper-based processes, a lack of adequate advice about court and tribunal processes, and a lack of prioritization of cases. So that's, as I say, that might be a leftover from the overall arrangement. It seems to me that the most substantive reform that they've suggested, or that they're going to sort of look into, which will come as no surprise, is that they're planning to digitize more of the possession proceedings that are presently digitized. They think that it provides an excellent opportunity to digitize, they say. So we'll see how that goes, considering how many of our clients struggle to use the internet. I'm hoping it's not a digitization that's going to affect the tenants, but I'm frightened that it will be. The other thing of interest on dispute resolution is that they are planning on strengthening and embedding mediation services for landlords and renters and preventing avoidable evictions. So there's nothing substantive about that in the white paper, but it does say that the rental mediation pilot, the findings there are soon to be published. So more on that soon. I think that's me. So I'll hand over to David, and then I think we can deal with questions at the end.
Good afternoon, everyone. Thank you very much, Marie. I'm going to talk to you about recent cases, and by recent I mean cases since we last did a possession update, which was I think late summer of 2021. Could I have the next slide, please, Ray? There are, I think, 6 or 7 cases, but the first one to mention is Clarion Housing Association against Carter. Clarion is a relatively new housing association, being an amalgam of 2 existing ones. This concerned the status of a member of the tenant's family where the tenant had died. So just to recap, the Administration of the Estates Act 1925 provides that when a tenant dies, the tenancy does not die with him or her. The tenancy has its own separate life. And therefore, if the tenant dies leaving a will, the tenancy devolves to the executors of the will. if, on the other hand, as is usually the case in respect of social tenancy, social housing, if there is no will, then the tenancy devolves to the public trustee. So the legal estate, immediately on death, without any formality being required, goes to the public trustee. And as a result, if a landlord wishes to terminate the tenancy, he, she, or it must deal with the public trustee, and in particular, determine the tenancy by serving notice on the public trustee. Now, if we're dealing with assured or secure tenancies, or indeed assured shortholds, until such time as they get abolished, the notice to serve is certainly going to be a notice to quit, because it's a condition of those sorts of tenancies that the tenant occupies the property as their only or principal home. If you're dead, you can't satisfy that criterion. So when the tenancy devolves to the public trustee, it loses its protection, whatever protection it had before, because that condition cannot be met. And I think all social landlords know that they have to serve a notice to quit, because it's got no statutory security of tenure. Now they serve it on the public trustee. The position, the question that arose in Clarion against Carter was, what was the status of an occupant of the property which was held by the now deceased tenant, where the occupant, the living occupant, didn't automatically succeed to the tenancy. And in this case, the occupant was not the spouse of the dead tenant, the member of the dead tenant's family. And Clarion served notice to quit on the public trustee before letters of administration had been issued. So letters of administration are where the public trustee, in effect, puts the person applying for letters in the position they would be if there'd been a will and they had been an executor. So Clarion, pretty quick off the mark, served the notice to quit before letters of administration are applied for, indeed issued by the public trustee. And indeed, letters still had not been issued when the notice to quit expired. So the question that arose was the tenancy terminated? The argument on behalf of the member of the tenant's family was that she, in this case, I think it was, had a tenancy in equity from the moment that the tenant with the legal estate died, and the court said, no, you don't. It didn't actually say what status she had, but it's likely that she was a licensee of the public trustee. Once letters had been issued, she was at that point capable of having an equitable tenancy in equity, but the tenancy had already been determined at the date that letters were required. So the notice to quit was valid, and therefore the tenancy had been properly determined. In fact, Miss Carter was successful for a rather complex chancery reason, namely that there had been a promise by the housing association and made to the original tenant, and she was entitled to rely on that promise. And so it was held that she could remain there for other reasons. But the key position is that a potential beneficiary, as opposed to an actual beneficiary, is not a tenant in equity. Next slide, please. Global 100 against Laleva. This is a case on CPR 55.82. Now, it is frequently the case that tenants with a potential defence go to court, an actual or potential defence, are in court at the first hearing, and they want the matter, and they want the district judge, it was always the district judge, to make directions rather than to decide the claim there and then. The district judges do have the power to decide possession claims at the first hearing, And in all probability, most such claims are decided at the first hearing because there isn't a defence or a potential defence. The issue that arose here is, what is the test for applying CPR 55.82, which, and the key words in that rule is whether the claim is genuinely disputed on grounds which appear to be substantial. So to take a typical case, you are an assured tenant and you're in rent arrears, and your landlord has brought a possession claim because you have these horrendous rent arrears. It's, imagine, £10,000. And in fact, what you want to put forward is a defence of set-off on the basis that you have a cracking counterclaim against the landlord who has failed to carry out repairs for forever. And so you go along to court and say, well, I want to resist the making of possession order because I've got this substantial counterclaim. And you would be seeking to rely on CPR 55.82. Now, just a word of warning here, it is very important that you that you submit a defence before the hearing, because it makes it much more difficult to argue that the direction should be made if you're just going along on the day saying, well, I've got this defence with no details at all. Anyway, the point that arose in Global 100 in the Labour is, what test does the judge apply to decide whether the claim is genuinely disputed on grounds which appear to be substantial? And in Global 100, the Court of Appeal said it is the same test as would apply if a party to litigation were applying for summary judgment. Summary judgment is dealt with in CPR 24.2, and which I've set out on the slide. So the court may give summary judgment if it considers that the defendant has no real prospect of successfully defending the claim or the issue, and that there is no other compelling reason for a trial. So that's what you have to establish. And as I say, it's much easier to establish if there is a defence in which sets out in detail why you say the claim should not succeed. Next slide, please, Ray. Lidderman and Hull, not at first blush a residential claim because it concerned a loan for 3.5 million charged upon a farmer's 350 acres, but nevertheless of significance when dealing with mortgage possession claims. There's not nearly so many mortgage possession claims as in days of yore, because lenders are cannier now and don't want to bust the market by seeking too many repossessions. But Section 36 gives the court the discretion to stay the execution of a possession order obtained in mortgage possession claims, or to adjourn it on terms. And the usual application that is made is that the borrower can pay it off within a reasonable period, which will depend very much on the remaining term of the mortgage and the amount that's owed and my ability on the borrower to pay. In this case, the farmer said that or submitted to the court that before making an order, and the order was for possession of the land because of the charge, the court had to establish exactly how much was owed, and that if it wasn't sure of the exact amount, then it had to stay the execution of the possession order or adjourn it until such time as that had been established. And the court said that there is no such general principle. It may well be relevant in a particular claim to decide how much was owed, but in a claim where there is absolutely no prospect of someone paying the amount, it was not necessary to go and establish exactly what was owed before exercising powers under Section 36. Next slide, please. Metropolitan Housing Trust against TM. TM is called TM because he suffered from a disability. He had a severe mental illness, psychotic. Metropolitan Housing Trust, as the name suggests, social landlord, very large social landlord, enormous numbers of properties, and they provided a accommodation for TM, who was has a severe schizoaffective disorder, and what was known by the psychiatrist as treatment-resistant paranoid schizophrenia. So he had great difficulties, to put it mildly, and there was no doubt that he came within the definition of a person with a disability for the purposes of the Equality Act 2010. Metropolitan knew all about his disability. Indeed, they placed him in accommodation, which was a specific development to provide for people with mental health difficulties. He unfortunately caused a lot of antisocial behavior. He exposed himself to a female resident. He was guilty of threats of violence and actual violence. So it's quite a serious case of antisocial behavior. And Metropolitan took proceedings on the basis of ground 14. So that's the sort of original antisocial behavior ground in Schedule 2 of the Housing Act 1988. Now, one of the defences put forward by TM was that the Metropolitan had not properly considered the public sector equality duty. So that's Section 149 of the Equality Act, which requires a public authority to do various things, including taking steps to have regard to the needs of a disabled person or a person under a disability. And the evidence that came out in the trial was that indeed Metropolitan had not considered this at all. And they sought to correct that by giving witness evidence at the trial. And their witness gave conflicting evidence. Their witness said that he was suggested that if this is the witness employed by Metropolitan, if he had gone through the various stages that the PSED required him to go through, the outcome could well have been different. And he may well not, and he was responsible for deciding to take possession proceedings. He said, well, I may well have done something different, but nevertheless, I consider that taking possession proceedings was a proportionate response, given all the other circumstances, namely the behavior of TM and the protection of other people in the 17 units that were specially designed for mentally disabled people. And the court, the county court made a possession order and said, well, yeah, the judge found that there had been no proper consideration of PSED, but nevertheless it had been corrected by the witness evidence, because the judge decided it had to be satisfied that despite the misgivings, it was a proportionate response. The Court of Appeal allowed the appeal on the basis that there's a great difference between carrying out a proper assessment for the purposes of the public sector equality duty and giving witness evidence in court. There's bags of authority in what the meaning of the PSED across a lot of different areas of law, and it's generally accepted, and this phrase comes up time and time again, that when considering the PSED, the duty is to carry out a proper process in substance with rigour and an open mind. And no doubt those of you who do homelessness cases will recognise those words, because they're sort of boilerplate paragraphs which review officers stick in their letters to just show how assiduous they've been. But anyway, what the court in this case said, really just giving evidence does not comply with that rigorous standard that has to be applied. They did go on to say, however, that you could correct a failure to deal with the PSED before the trial. So if, for instance, Metropolitan having initially decided to issue proceedings, not having carried out a public sector equality duty exercise, they could nevertheless carry out a separate exercise addressing themselves to whether they should continue with the proceedings, but it had to be a proper assessment. Next slide, please, Ray. Right, Croydon and Kalonga. This is a case on the so-called flexible tenancies. I have to say, this phrase really gets up my nose. It's about the government, when it creates new forms of tenancy, seems to come up with different descriptions of the sorts of tenancies to reassure people. So we have protected tenancies under the Rent Act 1977. We have assured tenancies under the 88 Act, secure tenancies under the 85 Act. We used to have protected shortholds, now got assured shortholds, all these sort of rather woolly expressions which are meant to give tenants some sort of reassurance. A flexible tenancy is really, it seems to me, is completely wrong. It's hardly flexible. We're dealing with a fixed term tenancy. It doesn't give any flexibility to the tenant at all. It actually is meant to enable a landlord to decide whether it wants to grant another tenancy at the end of it. Anyway, what happened in Croydon is that they granted Mrs. Kalonga, a fixed term tenancy for 6 years. Sorry, 5 years. This was it had a forfeiture clause. So, I mean, where you, as I'm sure everyone knows, in terms of the length of a tenancy, you can either have a periodic tenancy which rolls on from week to week, month to month, year to year, or you can have a fixed term tenancy where the end of the tenancy is predetermined by agreement when you sign up to it. And for forever, fixed term tenancies have only properly worked from the landlord's point of view if there's what's called a forfeiture clause in it. Because if you grant someone a fixed term tenancy for, say, 21 years and you don't have a forfeiture clause or some other way of bringing it to an end, then regardless of what the tenant does, you're stuck with him or her for the whole 21 years. So a properly drafted fixed term tenancy will normally contain at least a forfeiture clause. And a forfeiture clause means that if the tenant does certain things, then the landlord is entitled to forfeit the tenancy. In other words, bring it to an end before the end of the fixed term. And that's what happened in Miss Kalonga's case. Croydon granted her a fixed term tenancy subject to a forfeiture clause, but that was the only way in which the tenancy could be brought to an end before the end of the 5-year fixed term. They then sought to, they claimed possession against her using one of the statutory grounds, because although she is a so-called flexible tenant, she was a secure tenant of Croydon. They didn't go through the correct procedure to forfeit the tenancy, which is serving a forfeiture notice. They just served her with a notice seeking possession, and she defended this on the basis that the fixed term had not properly been determined, because a proper forfeiture notice had not been given to her, and she was successful. And indeed, the case went to the Supreme Court. And the Supreme Court said that, well, in relation to fixed-term tenancies, Parliament allows local authorities or the landlord to terminate in one of two ways, which has to be set out in the agreement. Either there's some sort of break clause. The break clause are normally associated with tenants giving notice to the landlord, but you can have a break clause the other way around. Or you can have a forfeiture clause. Unfortunately for Croydon, they didn't have a break clause, they just had a forfeiture clause. So the only way they could terminate the tenancy before the end of the fixed term was by going through the forfeiture procedure, which they failed to do. And as a result, Ms. Kalonga was successfully defended the case. If Croydon had a break clause, then they would have been able to seek possession, or to gain possession rather. Right, next slide, please. London and Quadrant Housing Trust against Stokes. This is a fascinating case on the facts. As I'm sure everyone listening to this knows, London and Quadrant is a truly huge social landlord, one of the biggest in the country. And two of their employees set up a sort of cottage industry of granting tenancies on behalf of London and Quadrant in return for money from tenants. This was not part of their contracted employment. And they were acting against the interests of their employer and indeed acting fraudulently. Well, they, I can't remember, yes, the tenant, the Stokes, was the beneficiary of the largesse of these two employees. Of course, you had to pay for it, but she nevertheless got an assured tenancy. But she wasn't the only one. They were doing this, they'd done this a lot. When they signed up, they used all the London and Quadrant forms. They used they only granted tenancies to people who had applied to London and Quadrant. So they used all the information which had been obtained through the housing trust. The tenancy agreement she had was a standard London and Quadrant housing trust tenancy. So it all looked completely above board, except of course that it wasn't. And eventually London and Quadrant discovered this. We don't know what action they took against the employees. Presumably they sacked them. They may well have been prosecuted for fraud by the police. I don't know. But the issue that arose is what was the position of the Stokes? Now, initially, not initially, London Quadrant brought possession proceedings on the basis that Miss Stokes had been a party to the dishonesty. The claim was that the tenancy had come into existence as a result of fraudulent misrepresentations. They weren't relying on the ground for possession. They were saying that the whole thing should be set aside for fraud, which is a perfectly proper way to deal with it, except the judge found that Miss Stokes was not a party to the arrangement. So the dishonesty was entirely unilateral on the part of the two employees of London and Quadrant. So to which London Quadrant said, well, it doesn't really matter. We still are entitled to possession, even though she wasn't a party to it, because they didn't have authority to act on behalf of the housing trust. Now, it is indeed true they didn't have express authority. Nobody in London Quadrant management had given them the power to just grant tenancies to who they like. But the court found that they didn't have, although they didn't have express authority, they had what's called ostensible authority. And ostensible authority is essentially that to all intents and purposes, if a dispassionate third party were looking at it, they would say, yes, they are clearly acting on behalf of London and Quadrant. and as it said in the law report, when a principal, that's London and Quadrant, represented to a third party that an agent, those are the two dishonest employees, had authority to act on the principal's behalf, and the third party dealt with that agent, so Mr. Stokes dealt with the dishonest employees, on the faith of that representation, the principal, i.e. London and Quadrant, was bound by the agent's acts to the same extent as if the agent, the dishonest employees, had the authority which he was represented, or they were represented as having. So it's unfortunate for London and Quadrant, but indeed they will just have to, and other landlords just have to ensure that their employees behave themselves. Next slide, please. Northwood and Fern. This is the case on tenancy deposits. So tenancy deposits are contained within section 213 to section 225A or C or something of the Housing Act 2004. I'm sure many of you will have relied upon the tenancy deposit provisions to resist a possession order for assured short-hold tenancies, because if a landlord grants an assured short-hold tenant and takes a tenancy deposit from the tenant, then it has to be protected in accordance with an authorised scheme. Certain notices have to be given, particularly prescribed information. And one of the documents that has to be given to the tenant is a deposit protection certificate. Again, I'm sure many of you in the audience will have come across these. Deposit protection certificate is a certificate from the authorised provider which confirms that the deposit has been received and gives certain information in it. It has to be signed by the landlord. And in this case, the deposit certificate was signed by the property manager of a corporate landlord. As the name suggests, Northwood Solihull Limited was a company. The argument for the tenant was it had to be signed by someone in a much higher position, like a director or a secretary of the company. But the Court of Appeal said, no, it's good enough if it's signed by the landlord's property manager, who acts as agent for the company in these circumstances. Next slide, please. Right. Lees and Kay, I'm now going to hand over to Daniel. This was one of his cases. Marie referred to it in her talk. As far as I know, I don't know if Dan knows otherwise, it's the only case so far on breathing space moratoria. Over to you, Daniel.
Thanks, David. Yeah, it's not quite the only case on moratoria. There's if anybody's been if anybody's been keeping half an eye on the endless saga of the Axnoller and Brake litigation, there has been, amongst thousands of other issues in that, there has been something on moratoria. I'll come back to that in a minute. I mean, I think probably what might be helpful is if I just start by very briefly summarising what happened in Lees and Kay, because it wasn't a usual possession type case that we're perhaps familiar with seeing, and then I'll set out a few thoughts on the breathing space and mental health crisis moratoria more generally. So what happened in Lees and Kay? This was a case, Miss Lees was a leaseholder of long lease of a flat. Mr. Kay was at one stage her upstairs neighbour. He brought a claim against her for harassment and nuisance and was awarded judgment in that. And over the course of it, got to the stage where Miss Lees hadn't paid the judgment debt, and he obtained first charging orders and then an order for sale for just short of £300,000 for damages and costs against her. And the order for sale provided that if she didn't pay the judgment, the total £300,000 by a certain date, then in the usual way that orders for sale work, a legal estate would be vested in him for the purpose of selling the property to recover the judgment debt, and that she would have to give possession to him of the property in order that he could do that. Ms. Lees didn't pay the debt, and also didn't vacate the property, and so the mechanism of the order for sale kicked in. And then what happened effectively was that Ms. Lees first obtained a breathing space moratorium. So that's the fixed term moratorium that's in principle open to all debtors that Marie talked about. And as a result, one bailiff eviction was cancelled, and then she obtained a series of mental health crisis moratoria, which was the second kind of moratorium that Marie mentioned. Perhaps, well, I would say this, of course, but rather unwisely, when it got to, I think, the second of the mental health crisis moratoria, Mr. K, or his, with the benefit of his legal advice, decided that actually the moratorium didn't prevent them from evicting her. By this point, it had been transferred to the High Court for enforcement, and they had a High Court writ and High Court enforcement agents, and they took the view that because the original judgment had been for nuisance, that it fell within an exemption from the moratorium regulations, and rather than have this determined by a court and then proceed with an eviction if they were right, they decided that evict first and ask questions later would be the appropriate way forward. So that happened, at which point solicitors got involved for Miss Lees and wrote and said, well, look, the effect of the regulation, this was a debt which fell under an existing moratorium, and therefore the effect of the regulations is that the execution of the writ of possession is null and void, and you should let her back in. There was no agreement as to that, so an application was issued for determination in the High Court, I think on the 16th of March. Shortly before that, before the application was due to be heard, Ms. Lees got notification that there had been a search on the land registry in relation to a potential purchase of the property, a sale by Mr. K. At which point the solicitors got in touch and said, just in case you're thinking about selling this property before we have a High Court hearing, you should be aware that that's a very bad idea, and obviously any sale would also be null and void, and we'd be in a terrible mess. There was further back and forth. Long and short of it was that I think 6 days before the hearing in the High Court, Mr. K's solicitors wrote and said, actually, we sold the property yesterday, so you should withdraw your application now. At which point Ms. Lee's solicitor said, no, we don't withdraw our application, we just make a further application for a declaration that not only the execution of the writ of possession was null and void, but also your sale is null and void, and your purchaser might have something to say about that. So this eventually reached a hearing in High Court at the end of March, and the court agreed with us that the judgment debt didn't fall within an exemption, and that was to do with the construction of the relevant exemption. And because of that, not only the execution of the writ of possession was null and void, but also the sale was null and void. And so the court granted an injunction that the person who thought they bought this property, a declaration that in fact they hadn't bought this property, and an injunction requiring them to hand over the keys and let Miss Lees back in. There was an application for possession for permission to appeal to the Court of Appeal, which was refused. So that's where the litigation has ended, at least in that respect. So yeah, as you can see, it's not. I mean, certainly, I don't think I've dealt before with representing a defendant to an order for sale, and that being the mechanism of possession. So it's slightly different to a rent arrears possession case, which is perhaps the most obvious application for us of the moratoria. But it does, I think, illustrate that the regulations and the moratoria granted under them are a potentially very powerful tool in respect for tenants who are facing rent arrears possession claims or mortgage arrears possession claims. In that the restrictions on enforcement, and indeed the power to undo any enforcement steps taken, are fairly strong powers and duties. A couple of points to note. The first is that Marie mentioned in relation to mental health moratoria that they can be available for people, for example, who are detained under the Mental Health Act. But in fact, the eligibility for a moratorium goes much wider than that. So Section 28 of the regulations provides that somebody's receiving mental health crisis treatment, if they're detained under various sections of the Mental Health Act, and it describes those, and it says always receiving any other crisis, emergency or acute care or treatment in hospital or in the community from a specialist mental health service in relation to a mental disorder of a serious nature. And certainly in Lees and Kay, it wasn't the case for somebody who was detained in hospital. So it's worth remembering that it's not restricted to just those very narrow class of case. The second point about obtaining a moratorium that should be made is that they can be granted they're granted on application to a debt advice provider. And that means either a person who's authorised under the Financial Services and Markets Act to provide debt counselling. And there's a list of those people available. I found a list on moneyhelper.org.uk. That shows the organisations from whom you can obtain a moratorium. And the other person who's authorised under the regulations is a local authority. Although I'd have to say I'm not sure, and it'd be interesting to hear from those in the audience whether that's something that's happening in practice. The third point to make about obtaining a breathing space is that whether it's obtaining a moratorium, whether it's a breathing space moratorium or a mental health crisis moratorium, it comes into force on the day after the Secretary of State causes an entry to be made on the register. So in practice, what happens is that you make an application to a debt advice provider. They then, if they're satisfied that you qualify, enter the details on a portal. And there was some discussion in Lees and Kay about whether that enters you onto the register automatically or whether there's some delay. It seems in practice it happens that you're entered onto the register that day, but your moratorium only starts the next day. So if somebody turns up on the day of eviction, then realistically a moratorium is not going to be a tool that you can use to stop them being evicted, because the protection of any moratorium would only begin the next day. But it is something otherwise that I think is certainly worth looking into, particularly where you think that there might not be other defences available. I'm going to look in a minute, actually, I'll move on to dealing with the question that's come through about breathing spaces, and then we can move on to any other questions. A question's come from Stephen Cutter. I don't know if you can all see the answered questions, but he says, breathing spaces, if a repossession claim has succeeded and the county court has arranged for eviction to take place through bailiffs, would/should a breathing space prevent that from taking place? And if so, in what form should a claimant inform the county court of the breathing space? And Marie's very helpfully dealt in her written answer with the second part of that question, which is how does a creditor inform the court of a breathing space? And so you can hopefully see that answer there. In relation to the question about would or should a breathing space prevent eviction from taking place after a possession order has been obtained, that comes to the question of what is prohibited under a moratorium. And I don't know whether, in fact, the easiest way, is it possible to stop sharing your screen so I can share mine? Because it might be helpful to just look at the regulation very briefly. Let's see if we can do this. So you should all now be able to see, yeah, you can see a copy of the moratorium. And can you see there, Regulation 7, effective moratorium? So this is really the key provision in relation to the protection that a moratorium provides. And it says 7.1, a moratorium has the effect specified during the moratorium period. And the key is that the 7.6 says there are 4 broad things that you can't do during a moratorium. You can't require interest to be paid that accrues during the moratorium. You can't require fees, penalties, or charges to be paid that accrue during the moratorium. And then C, you can't take any enforcement action in respect of a moratorium debt. Or D, instruct an agent to do any of those things. And the key is, what is an enforcement action? And the first thing to say there is that the axe nullimer and break case, it was argued that enforcement action is limited to the things that are described as enforcement under the civil procedure rules, and the court said no, enforcement is to be given a broad meaning. And you then see here the definition of enforcement action, and a creditor or agent takes enforcement action if they do any of the following things. And there are various specific ones, and so it's worth looking. For example, for our purposes, it's going to be commonly be the case: serve a notice to take possession of a dwelling, or take possession of a dwelling having served such a notice. Sorry, those are the Welsh ones. J, serve a notice to take possession of a dwelling house under grounds 8, 10, or 11 in Schedule 2 Housing Act 1988. So there are specific things that you're prevented from doing. But then there are also more general provisions. So under 7B, take a step to enforce a judgment or order issued by a court or tribunal before or during a moratorium period regarding a moratorium debt. And so I think the question that Stephen asks about whether once you've got a possession order, a moratorium prevents you from enforcing it. There's obtain a warrant, but there isn't enforce a warrant, and that was one of the things that came up in the Lees case. But certainly the court accepted in Lees that 7B was broad enough to catch the enforcement of it, because it was, in our case, there was an existing writ of possession that was then enforced, and the court said that clearly comes within 7B. So I would certainly say that despite there being a number of specific things you can't do, actually 7B is going to be very broad. If you take the decision in Axnoller and the decision in Kay and Lees, those are authority to say that most things, and certainly the step that Stephen describes, are going to come within it. That also, I think, is the answer to another question that occurred to me on looking at this, which is the specific provision made in relation to 1988 Act assured tenancies, but not, for example, in relation to secure tenancies. But I think if a local authority, presumably they wouldn't be the one who had granted the moratorium, it would be one of the other debt advice providers. If a local authority sought to enforce a rent-arrears possession order, you could probably rely on 7B. So I think those are the thoughts that I wanted to outline in relation to the moratorium regulations. I don't know if I'll just have a look to see whether we've certainly got at least one other question in the Q&A, which is on mental health breathing space moratorium. And then we've got another one that's come through in the chat. So perhaps if I take the one briefly in the Q&A, and then we can move back over to the ones in the chat. So the question that's come through is, could a mental health breathing space moratorium be used when the tenant's dependent child is under an acute crisis care in the community? I think the answer is probably not, because the entitlement to a, the entitlement, I'll stop sharing my screen now. How do we get back to the main window here? Just give me, oh, there we go. Because the entitlement to a mental health crisis moratorium is in relation to a debtor who is under mental health crisis. So it's not, connection to somebody with mental health, who's in mental health crisis, wouldn't be sufficient. And you can find that in Regulation 30. So unless either David or Marie has anything to add on those questions, there's one that's come through in the chat, which I think is probably I'll direct to Marie in the first instance. William Flack says, am I missing something, or does and this is in relation to the white paper, does the 3 times over 2 months rent arrears not make sense? For example, if the rent arrears are 2 months or more on one day, but a week later they dip below, and then back up, and then the same thing happens a bit later, is that your 3 times? The tenant would presumably be better off keeping the arrears above 2 months for as long as necessary, and then reducing them, because that would mean they would only go above once. Marie, do you have any observations on that?
Yeah, yes, the trouble is we don't have the wording of the ground, and I think it might, I might be being quite cynical. I think it's because they haven't worked out the wording of the ground, because it's quite odd what they're trying to trap. So in the guidance, in the white paper itself, it doesn't say anything beyond what I've said there. So on that reading, it would be better to keep up the arrears than let them drop down. So if they drop down 3 times, you're in trouble. But if they drop down, say, only once before the hearing, or indeed twice, then that won't make out the mandatory ground. And I thought, oh, okay, well, maybe if you go back to the initial consultation paper where they give a bit more detail and all this stuff, so that was in July 2019. A few years ago, they have a consultation, sort of the results of the consultation. But that's not any better, because that says, and it's at paragraph 3.30, if you want to look at it, that the tenant has been in at least 2 months arrears 3 times within the previous 3 years. So that's the exact same problem. And then it says it's trying to prevent occasions when people pay these debts down on 3 occasions and there's a pattern of behavior. So I don't know if David or Dan have any other ideas, but to me, you'd be tempted, not that I'm saying that you should, but you'd be tempted to tell people to avoid paying it down. It sort of creates more mischief than it cures.
I agree with Marie that it does very much depend on the wording, but I think the wording is going to be extremely difficult. I mean, generally in these white papers, they just put down, what they would like to do. But most tenants are get themselves into arrears just on a regular basis. I mean, most tenancy agreements say you've got to pay in advance. Tenants don't think that. They think as long as they've paid their rent within the month, and they get to a nil balance at some stage, then they are up and running. Well, if you pay 1 day late and you're meant to pay on the 1st of the month, that's arrears. So I have severe doubts about whether this is going to be of any effect whatsoever.
Yeah, I mean, the only thing I would add on all of that, I mean, I think that's absolutely right. It will also, I suppose, it will make the counterclaims much more difficult, because at the moment you can run a counterclaim with a defensive set off, and it's very simple to work out, because the court only has to work out what damages are owed at the date of the hearing, and if those are sufficient to bring you under 2 months, then that will defeat the claim. But in fact, the way that a set-off defence works is it means that the rent, or has worked so far with statutory grounds, is that it means that the rent is not lawfully, the full rent before set-off is not lawfully due, because there's a defence of set-off. And so it will then require, I imagine, the court to work out at each of the 3 points or more that you went above the threshold, what would have been your entitlement to set off at that stage, and then to work out whether, even after setting off at those various points in time, you have the 3 times. So I think it is going to make things unbelievably complicated if that's the form that it ends up taking. So I think those are all the questions that have come through so far. I don't know if anybody else has any burning questions. Get them in the chat before I manage to wrap up. Otherwise, I don't know whether Marie or David, you have anything further to add about anything that we've been talking about, anything that's occurred to you?
Nothing from me.
I don't think so. No.
Very good. Okay, in which case, nobody's been quick enough to the draw with burning questions. But of course, in the usual way, if you think of something and wish you'd asked it, there's any follow-up once you've received the slides, then I'm sure if you send an email to one of us, then we'll try and help if we can. So thank you very much, everybody, for coming. I hope that's been useful, and hopefully see you all again on the 13th for the next seminar.